All right, everybody, as Nancy indicated, I'm Jim Whitlatch. I'm an attorney here in Bloomington with Bunger & Robertson, and I've done Life Designs Works for a number of years now. I do a lot of healthcare law, a lot of employment law. So what I want to talk with you about, and feel free to interrupt me at any time, ask questions or anything else. I want to talk to you a little bit about harassment. What is actionable harassment? What do you have to be concerned about as a supervisor regarding your employees? And also, as indicated, talk about the Family Medical Leave Act. Why do we care about harassment? Well, we care about harassment for a number of reasons. We want to protect our employees from harassment. We want to protect the organization from liability. We want to protect you as individuals from liability, because there can be individual liability with harassment. Let me talk to you, however, about the difference between what is legally actionable harassment versus harassment. I get people that come into my office a lot of times and saying, my boss is mean to me, or somebody, my coworkers is mean to me, they're harassing me. They're harassing me because they don't like me. Or they're doing mean things to me. And why are they doing mean things? Because they don't like me, or because they're a next door neighbor and their dog gets in my yard all the time, or I'm dating their ex-boyfriend or ex-girlfriend or something like that. That is harassment. Those types of things, somebody being mean to you, somebody doing things, might be considered harassment. But it is not necessarily legally actionable harassment. It may not be the way that you want to run an organization where people are mean to each other, and it may mean that it's something that you want to deal with as an employer or as a supervisor. If you have two of your employees who are harassing each other, you may need to deal with that as an employer, because it's not a good work environment to be in. But it doesn't mean that the employee has an actionable claim against you. Actionable harassment is only if you're harassed because you're the member of a protected class, and your harassment involves that protected class. And generally, we're going to go into these, but generally, if you're harassed because of your sex, if you're harassed because of your race, if you're harassed because of your national origin, if you're harassed because of your religious beliefs, if you're harassed because you have a disability, those are actionable type claims. If you're harassed because somebody doesn't like you, that's not a good way to run a business maybe, but it's not legally actionable. Now oftentimes harassing someone for something, harassing someone because of their weight, is that illegal harassment? Again, it may not be nice, but it may or may not be protected. Now, the law is starting on things like weight. They're starting to say, well, that's really could be considered a disability. That could be harassment that's protected by the law because it's a disability. Or one that we're having that traditionally wasn't protected, but and technically isn't protected when you look at the statute, is gender identity, or LGBT issues. The law traditionally didn't, in most locations, didn't give protection. Now we're getting more protection for that. Bloomington has a city ordinance that protects gender identity and those types of things, but the law didn't necessarily sex harassment. The question was, does sex harassment correct gender identity? The Equal Employment Opportunity Commission, which governs sex discrimination and things like that, is taking the position now, and courts are taking the position, that gender identity is protected, even if we don't have a specific statute that protects it. It's protected under the sex discrimination claim. Even though traditionally sex was, am I being discriminated against because I'm a woman? Am I being discriminated against because I'm a man? It wasn't traditionally things like my sexual preference. It wasn't things like gender identity. But as we all know, that's a very popular thing. Not popular is not the right word. A very cutting edge or issue that's being dealt with now is issues of gender identity. So we'll talk more about that. We'll talk about the relevant laws, type of harassment, and recognize harassment. Hit the button there again, if you would. Again, why are we concerned about workplace harassment? We've done that. Switch again. Harassment is unlawful discrimination. Workplace harassment is a form of unlawful discrimination prohibited by local, state, and federal laws. Again, we're dealing with, in Indiana in particular, we're dealing with 3 laws that might apply to you. We have a federal law, which is generally Title VII. We'll talk more about that. We have a state law, which we have state laws regarding discrimination that pretty much mirror discrimination into the federal law. Title VII, again, that's race, national origin, sex, disability, religious beliefs, age. You can be harassed if somebody's harassing you because of your age, if you're over 40. So for instance, going back to my first point, somebody being harassed and made fun of because they're too young, because they're 25 and people start making fun of them, oh, you're just a baby, you're just this, you don't know anything, you're too young to know anything. That may be harassment. It may not be nice, it may not be the way to run your organization, but that type of harassment does not give that person a legal claim. Now, harassment, even that kind of harassment, can reach a level where it may give a claim if it becomes sort of criminal activity. If somebody becomes aggressively or violently harassing somebody in the workplace, then that can be that can give that a different type of harassment. That's more of a criminal. But we're talking about harassment based upon a protected class. So you have you have state laws, federal laws, and then local. We have the Bloomington Civil Rights Commission, which does its own, can do its own looking into discrimination. As I mentioned, does have an ordinance passed here that does protect sexual preference, does protect gender identity, does protect those things. Now, the protections aren't incredibly broad in the local ordinance, but we do have them. And all of these organizations work together. If there's a charge or claim brought of discrimination, any of those 3 agencies that deal with this, for the federal level, you deal with the EEOC. You may have heard that. EEOC stands for Equal Employment Opportunity Commission. They have offices in all states, including they have an office in Indiana, in Indianapolis. If you go to their website, you can find a lot of information about that. They investigate claims. The Indiana Civil Rights Commission also can investigate claims, and they can investigate claims for the EEOC, or the EEOC may investigate claims that the Indiana Civil Rights Commission may deal with. Same with the Bloomington Human Rights Commission. They can investigate claims. To give you some quick background that you may not know, but if you ever get involved in an any type of discrimination or harassment type claim, a harassment claim typically has to be first, before it can be go into any lawsuit, first has to be filed as a charge of discrimination or an allegation of discrimination or harassment with one of these agencies, either the Bloomington Human Rights Commission, the Indiana Civil Rights Commission, or with the EEOC. Typically, we'll find with most employers that the charge of discrimination, that's when it's first filed, is charged with either the EEOC or the Indiana Civil Rights Commission. And that's a prerequisite. And there's a relatively short period of time that an employee has to bring a harassment claim that has to be investigated by the EEOC. That claim, depending on the type of harassment it is, that's usually somewhere between 180 and 360 days they have to bring a charge of discrimination or a charge of harassment. So if somebody's claiming they're being harassed and they're harassed today and they don't do anything for it, about it, and they're not harassed again, they don't do anything about it for 16 months or 13 months, or in some cases 6-7 months, then they are outside the time frame that they can bring a charge of discrimination or harassment, and they can no longer bring that claim before the EEOC, And the bringing that claim before the EEOC or the Civil Rights Commission is a prerequisite to be able to file a lawsuit. So part of the way the system works is they want to get the EEOC to investigate these claims, or the Indiana Civil Rights to investigate these claims, as a way to try to avoid them going to court, so that they investigate them, they try to deal with them, they try to settle them if there's something to do, or they say there's no claim here and hopefully the case goes away before they get into court, but they have a relatively short window. If they don't get satisfaction from, the employee doesn't get satisfaction from that investigation or the results of that investigation, then they are given what's called a right to sue. And typically, especially if it's harassment that's involving Title VII, one of the federal regulations, they can sue in federal court. And they, after the investigation's done, and they're told the investigation's done, the EEOC is not going to do anything, and typically they don't, other than try to make the investigation and broker a resolution. If they're not going to do anything, they give what's called a right to sue letter to that employee, and that employee then has 90 days from receipt of that letter to decide whether they want to file a claim in federal or state court. So they have to file within 180 or 360 days, depending on the type of claim it is. After they do that, and it's investigated, and those investigations can sometimes take 3 to 12 months to have an investigation. And you'll get, as an employer, you'll get a charge of discrimination typically, although interestingly we had one recently with Life Designs where they sent it but it didn't get, and they closed it so quickly that we didn't even have to file a response to it. But usually in 95% of the cases, when you have a charge of harassment or something that's governed by Title VII, you'll get a notice from the EEOC and they'll ask you for information. So you as a supervisor, that's when you'll get in. You'll say, hey, somebody will come to you and say, hey, we got this charge of discrimination by one of your, somebody that you supervise. We need to gather information about this incident. And then we need to talk to you about how you deal with those types of incidents, how we respond to that. The EEOC will then investigate it. The EEOC might interview some of the employees. If they interview you as a supervisor, you have the right to have an attorney there representing the organization and you, given the circumstances, to be with you if they interview you. But they also have the right to contact non-supervisory employees, and we don't have the right to be present when they talk to them. Or a lot of times they'll do it by phone if they do it. My experience over the last, 10 years ago, they used to do a lot more interviewing employees and interviewing supervisors. I don't think I've had a case in the last 5 or 6 years where they've actually contacted anybody. Now they'll ask for a lot of documentation, they'll ask for responses, but they're less and less, I think just because of the volume of cases, they're less and less actually doing the interviewing process. And whatever the EEOC decides is not binding on anyone, yeah.
Does the Bloomington Human Rights Committee have a similar, I know it's not a statute of limitations, but
it's,
on
yes.
a timeline?
Yes, yes, yeah. Yeah, and the Bloomington Human Rights Commission is not particularly active. They may get something that they get their hands on, but I've been involved in Bloomington Human Rights Commission investigations, and I've had some, but they're not as active. They just don't have the staff to be real active on doing those types of things. So we have that's the process. Now, if a case goes to suit, they file within that 90 days, then the suit process is going to go through, and the process of filing a suit usually takes 2 to 4 years to get it through trial. So a case, if somebody claimed that they were discriminated against today, filed within, let's say, 180 days with the EEOC took a year to investigate it, give a right to sue. At the end of the 90 days, the right to sue, they file the suit, and we go through the court process and the case is tried. From today's date to when that case would be tried, we're probably talking about 3 to 6 years to get to that process. Now, having said that, virtually no cases go to trial. I'm not saying none go to trial, but it's a very small percentage. Less than 5% of the charges that are filed, probably less than 2% of the charges that are filed go to court, to where a jury trial or a trial is done. Most of them go away with nothing happening, with no payment being made or nothing happening. And then the other ones that don't go all the way to a trial get settled somewhere along the process for $500 or $200. Sometimes, depending on the circumstances, they're settled for more, but most of the time the EEOC investigates something, says there's nothing there, just like the one we just had recently. Before we even knew really that there was a charge, they wrote back and said, we've investigated this, there's nothing there. That's the response you get most of the time, but there are occasions when there is an issue that you're concerned about and you enter into discussions, mediation, and try to settle it, sometimes most of the time for a very nominal amount, sometimes for more than that. You get a release and try to resolve the issue. You don't want the consequences are they create potential liability for life designs as well as the individual harasser. If you get into litigation and you get into these cases can become incredibly expensive if they can survive the investigation, if they get into suit, if somebody can find an attorney that's willing to represent them, if they have a good claim, which is a very small percentage of them. But defending a case like a true harassment type claim that's actionable, that's a good claim for the employee, you can easily, if you take it to trial and through trial, and maybe not even to where you actually have to try the case, the attorney's fees in defending a claim like that can be well in excess of $100,000 to defend a claim like that, which is why you don't want to get into them. Then if you lose a claim like that, or the risk of a claim is that not only does the employee get things like lost wages and emotional distress and things like that, but they can also get what are called punitive damages if somebody thinks you did something really intentional to harass this patient or this employee. And they can also, which is really a lot of times what these cases come down to and why attorneys are willing to take them for employees, is that the statute allows the employee to recover their attorney's fees. And so the attorneys have figured this out. I've settled cases within the last 3 years, not for Life Designs, but for other employers. I've settled cases where the settlement was $30,000 and the attorney fees for the attorney who represented the employer were $22,000. So a lot of times these cases become about the attorney representing the employee getting their fees paid, because unlike most lawsuits where an attorney is not entitled, even if successful in the case, to get their attorney's fees, in a harassment claim or a discrimination claim, the attorney who represents the employee, if successful, they have to be successful, is entitled to their attorney's fees, and those can be huge numbers, because they're going to put a number out there that's higher than, they may, if you took a case all the way through trial, my guess is the attorney's fees and the employee would put out would probably be close to $250,000, plus whatever the damages are that the employee has. Now, as I've indicated, it's less than 3% of the cases that ever go to trial, and my guess is there hasn't been an employee harassment case to go to trial in Indiana in the last 2 or 3 years. So it's very rare, but you have to evaluate the risk of going to trial when you try to settle a claim like this. So it can be an expensive type process. Now, you have, I believe you have employee practices liability insurance. Do you guys know? So that covers some of that expense. We have some insurance that actually covers if we're charged with harassment, but it typically has what's called very high retainage or deductible amounts, so it still is a cost and it doesn't cover for everything. So there's still a risk, even though we have insurance out there. That insurance is not cheap either, and certainly goes up if we have a claim. When we talk about harassment, the one that most probably comes to mind is sexual harassment. But harassment also applies, as I indicated earlier, to anyone who's part of a protected class: race, color, national origin, religion, age, disability, and there's even, these are the Title VII, the federal Title VII, there are even some other. Harassing someone because they've gone on FMLA leave can be actionable harassment, or retaliating against somebody. If you could switch to the next slide. Here I was just talking about some statistics. This is nationwide. In fiscal year 2015, nationwide, in just 1 year, this doesn't include open claims or claims that have been filed in prior years, they're still open. There are 89,385 new charges of discrimination. Now, discrimination includes, within this subset, set of discrimination includes harassment. There were 2,700 in fiscal year 2014 filed in Indiana. So again, discrimination, which includes harassment. 23,000 of these 89,000 were based upon harassment. So about a quarter of these, or a little more than a quarter of the 89,000, this is in 1 year, were based on harassment. And the amount of settlements paid, or monetary amounts paid in those cases, was $95.9 million. Again, this is nationwide, but you can see the amounts that we have here. And of those harassment cases, 6,822 were sex harassment, 46 million in monetary benefits paid out of those in 1 year. Again, nationwide, but you can see it's an issue. The number of suits filed, 167 filed, 144 were resolved in 2014. The other ones are probably still pending. In those suits, 22.5 million, again, in fiscal year 2015. Again, 174 filed, 171 so far have been resolved, with payments of $65 million. None actually tried, but still significant amounts of damages paid. Next slide. And please shoot up your hand if you've got any questions. Go to the next one after that. All right. What are the relevant laws? Well, we talked about this a little. Title VII of the Civil Rights Act of 1964 is where the employer has liability for discrimination, and discrimination includes harassing someone who's a member of a protected class. The Civil Rights Act of 1981 amended Title VII to allow compensatory and punitive damages for victims of intentional discrimination, which would include intentional harassment, which is a subset of that. Protected classes, again, race, color, national origin, religion, sex, age, disability, and genetic information. In certain circumstances, the harasser, not just can the employer have liability, but the harasser can also have liability. Next slide. The state law also mirrors the federal law. Again, race, religion, color, sex, national origin, ancestry, disability, age, and status as a veteran are protected under the state statute. Again, harassment for any being a member of, harassment related to somebody being a member of this class is included as well. Now, the primary differences that don't really apply to you between the Indiana Civil Rights and the EEOC Title VII, the federal law, is that the federal law, to have it be applicable to an employer, you have to have at least 15 employees. Well, you easily meet that requirement, so that's not an issue. The Indiana Civil Rights statute actually says, depending on the type of harassment or discrimination, it can go down to somebody that has 5 or 6 employees. If you have less than that, then these statutes may not apply to you because there's certain minimal size employers that they don't apply to. The Bloomington Human Rights Ordinance, which prohibits discrimination, including discrimination, as I indicated, sexual orientation and gender identity, although the current case law in the EEOC takes the position that discrimination against sex, which is protected by both the Indiana Civil Rights and the Title VII, includes protection against harassment or discrimination based upon sexual orientation or gender identity. So those, even though it's not entirely clear at the state or federal level whether that's protected, the cases and the federal governmental agencies like the EEOC are taking the position that they are protected. And as you know, we're getting into the whole issue of use of restrooms, locker facilities, those types of things. The general rule in that, well, first of all, the general rule would be my advice is that you not, and I'm sure nobody would, but that you make sure that your employees don't harass someone because of sexual orientation or gender identity. Because even though there is an open question whether they're protected under the state or federal law, the trend seems to be going that they are going to be protected under the sex discrimination. And then you have the issue of how you deal with someone in the restrooms and things like that. And the current status of the law seems to be, and I just attended a conference where this was discussed, that the conventional wisdom and the best advice to give on that is that you treat them based upon their gender identity that they refer to themselves as. So if they consider themselves a woman, you have to give them access to a woman's restroom in that type of situation. And if you get into that issue, we can talk about it more or deal with it more down the road. It certainly has, I've dealt with it. We represent the school corporation. I've dealt with it there. Represent the hospital. I've dealt with it there. And everybody's going to deal with that at some point. So next slide. What is harassment? We're going to start out focusing on sexual harassment, but keep in mind that all forms have substantially the same analysis. Again, harassment on disability or age or race, whatever. Next slide. So in sexual harassment, at least, when we deal with that, there's two types of harassment that we deal with in sex harassment. The one that is kind of the traditional one that we always used to hear about, that we don't hear about as much anymore, although it still happens, but is pretty obvious to everyone, is a tangible job action or quid pro quo. If you have sex with me, I'll promote you, I'll pay you more. If you don't have sex with me, I'm going to treat you poorly, or I'm going to fire you, whatever. It's in return for sex, you'll get treated better. That's oftentimes a supervisor to an employee or someone who has authority over someone else. We would all recognize that as sexual harassment and actual sexual harassment. And that's one that's really pretty specifically to sex harassment. You don't typically see, well, you wouldn't see that kind of harassment if somebody's harassed upon age or race or something like that. So that's one, and we're not going to spend a lot of time talking about that one. That's pretty obvious, and people would recognize that as sexual harassment. But tangible loss can include things like refusal to hire unless you agree to date me. It doesn't even necessarily have to be that you have to have sex with me. It can be uncomfortable pressuring someone to date you, asking personal questions about somebody. Those will get into more harassment type issues or hostile work environment. I'm going to discharge you, failure to promote because you didn't have sex with me, reassignment that has an adverse impact on you, or significant change in benefits, again, because you didn't agree to have sex with me or some other action like that. Next slide. Only supervisors have the power to affect the terms and conditions of an individual employment. So typically this is a supervisor-employee type situation. And an employer is strictly liable for a supervisor's misconduct regardless of the employer's knowledge. So if you have this going on within your organization, even if you didn't know it, you as an employer can be responsible for damages related to this type of sex harassment. So it's important that, again, that you do education like this, that you educate people, and that you tell your employees if something like this is going on, tell us so we can deal with it. That's the best way to try to do that, is to educate your employees and to have policies, which I know you have, and I think you're going to talk about those in a few minutes, is to have those policies so employees know they can, if it's their supervisor, they know where to go. If there's supervisors involved, you can't complain to your supervisor or whoever supervises you if you're being harassed by that supervisor. So you have to have other outlets to go to, and it has to be clear to the employee. And the reason to have that is burying your head in the sand as an employer does not protect you from that type of harassment. So you want the employees to come to you. So harassment that we're going to deal with more often, whether it's sex or race or age or religion or disability, is going to be that a hostile work environment has been created. This is the harassment that, other than the quid pro quo, that we're going to deal with. And that kind of harassment is, again, we'll start out with sex, but you can apply this to unwelcome conduct based upon a person's religious beliefs, or unwelcome conduct based upon a person's age, or unwelcome conduct based upon a person's disability or national origin or race. But we'll talk about it again initially in the context of sex. Unwelcome conduct based on a person's sex has a purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment. So we're talking about a hostile work environment. Are you doing something to intimidate someone because of their sex, their race, their color, to create a hostile work environment? The harasser may be a supervisor or a non-supervisor. So unlike the quid pro quo, where it's typically a supervisor who has the ability to affect your job, do you get a promotion or raise or not, and the supervisor is the one that can affect that. In a hostile work environment type of harassment, the harassment can be a supervisor or a non-supervisor, and can be someone who is not even an employee of the organization. So if you have a vendor coming in and that vendor is harassing someone either sexually or something else, the organization has an obligation to protect that employee from that harassment. If you have a customer or a customer's family who is sexually harassing someone or creating a hostile work environment because somebody is part of a protected class, you as the employee are protected from that. You as a supervisor or employer have a duty to deal with that issue to protect that person. So it's not just employee to employee, it can be outside party to employee when that employee is in their work environment and working as an employee of Life Designs.
Where do you start class again, anybody?
It would fall under this category if a supervisor threatens an employee for not cooperating and submitting to his sexual advances but does not carry out those threats. So again, just creating that hostile environment related to one of these protected classes. Okay, next slide. Elements are, the employee has to belong to a protected class. Again, what I'm saying is, if you're being harassed because of some other reason that's not related to being a member of a protected class, it may not be good for the way you run your business. You may want to deal with it effectively, but it doesn't give an employee a legal action. But if it is a hostile work environment related to protected class, it does give them protection. The activity or harassment has to be unwelcome. If it's a banner back and forth, it's probably not a good idea because you never know when that welcoming is going to end. But it has to be unwelcome. For sex discrimination, it has to be based on gender. I'm being harassed because I'm a woman. I'm being harassed because I'm a man. Harassment has to be severe or pervasive enough to affect a term or condition of employment. So one off-color joke, one comment is not a good idea because you never know how somebody's going to deal with it. But to really fit within the definition of actionable harassment, it has to be severe or pervasive enough to affect your employment or how you feel about your employer. And here, the employer knew or should have known and failed to take prompt and effective remedial action. Not an issue with the supervisor. So if a supervisor harasses, the employer is going to be held to know that information. But let's say a customer is harassing you, or a fellow employee is harassing an employee. If the employer doesn't know that, or didn't have reason to know it, and that becomes a pretty subjective argument. Should the employer have known when something was going on, or once you do know, employee complains saying, hey, the father of customer Y is acting inappropriate, is making comments to me that are of sexual nature, it makes me feel uncomfortable, I don't want to go to that job site anymore. Now you're on notice of it, and you as an employer have an obligation to deal with that. Or if you should have known that, you're at the job site as a supervisor, you observe it happening, and you don't do anything about it, that's going to be, you should have known, or you should have, even if it wasn't reported to you by that employee that's claiming they've been harassed, they should have known that and failed to take effective remedial action. So that's why when you want to encourage employees to report to you, but when they do report, the people that need to investigate that and take action to make sure they deal with those issues. Next slide, please. So let's talk about the specific elements. What does it mean to be unwelcome? Just because conduct is voluntary does not mean it is welcome. So just because somebody doesn't seem to say, hey, that's terrible, or that's nasty, or don't say that to me, doesn't mean that it's welcome. Unwelcome is when it's uninvited and offensive. The complaining individual must show that he did not want, invite, solicit, or encourage the conduct at issue. Oftentimes in sex harassment, you'll get into a situation where two employees will have this bantering back and forth. It's who can tell the most off-color joke to get a rise from the other one, and they may actually, two of them may actually enjoy it. But then at some point, something goes wrong, and one of the employees gets mad at the other one. You can believe that they're going to come to you and say, that wasn't, I was doing that, but it's because I was scared not to take part in that conversation. So you certainly want to address that and not have it happen. And the other thing you have to be worried about is those employees are working in a house together or something else, and there's 4 other employees who don't enjoy hearing it and who feel that that creates a hostile environment, even though they're not directly involved in those jokes, or somebody looks at them and says, isn't that funny, or something like that. That's creating, and that could be a hostile work environment, because those other employees, or even the one that's involved in it, may not feel that it was really solicited or encouraged. They may have a different interpretation of what was going on than the employee who was involved. Yes?
What if a customer is making obscene, unwanted, racist remarks to a staff over and over again, and the staff has told the employer about it, but the employer doesn't do anything about it?
Right. Well, then you're going to have to deal with that. The employer is going to have to deal with that. Now, you've got part of the issue that I suspect that you have is you have customers who are probably hard to regulate there. So the question is that type of situation when you have a customer that does it not because they're doing it necessarily to harass someone, but they're doing it because that's their disability or tied to their disability.
Right.
So that one's a gray area, because then the question becomes, is it, in that circumstances, is it offensive? Sure, it's offensive on some level, but if it's with somebody that's got a disability that can't control their actions, just like sexual harassment, sexual scenario where they deal with that. Now, they doesn't mean that an employer and employee has to be safe, has to be protected from those, but it may not lead to where it's this type of scenario, but it's something that has to be looked in, and is there a way to deal with this? But you probably would, this customer, no matter what somebody says, may still make racist remarks to anybody that comes in the door, or sexual remarks, and And if it's a safety issue, then the decision may have to be, we're not going to treat that customer anymore. Or it may be that we need to protect you, somebody else may not be bothered by that, we'll try to deal with those issues. But in your business, some of these issues, especially when they come from a customer, are tougher.
This was a tough situation. It was hard to tell where the customer's disability ended and where intent began.
Right,
But it was done to intimidate,
right,
you know, but
Right.
it was tough.
right.
And
Yeah.
generally for people receiving supported living services or residential services, if they have those types of behaviors, the team has met and there's generally a behavior support plan in place addressing both proactive and reactive steps to how to respond and teach them otherwise.
And this wasn't supported living.
Yeah,
This
Yeah.
was in a housing development.
Yeah.
So,
Yeah, yeah. So, next slide. As far as based on gender, this could be things like, well, you're a woman, you can't really you're not tough enough to do this job, or something like that. Or you're a man and you're not sympathetic enough to do this, or a man could never do this job. It can be either way. It can be male or female, gender bias. The question is not whether harassing conduct was sexual in nature. Was the conduct directed toward the employee because of his or her gender? I want a woman in this position. You're a woman, you can't do this kind of work, or you're a man and you don't understand this. If it's based upon gender, that can be sexual harassment. Male employees may be sexually harassed, and there can also be same-sex harassment. So female to female or male to male, if it has a sexual element to it and there's harassment related to that, that can also be actionable sexual harassment. What is severity or pervasiveness? In other words, to be a hostile work environment, it has to be very severe. It has to be, not very severe, it has to be severe and pervasive. Well, what does that mean? Frequency, how often do they tell the dirty jokes? How often do they make racial comments? What's the severity? Whether it was physically threatening or humiliating. If it was, that's going to take less. Whether it interfered with the employee's work performance, obviously is going to take less. Whether the alleged harasser was a co-worker or supervisor, if it's a supervisor, it's going to be much less of a standard that it's harassing versus a co-worker. Employee must show that the conduct created a subjectively hostile environment. And the standard is, would a reasonable person on the outside look at the behavior and feel that that was hostile or creating a hostile work environment. Sometimes you will get people who are hypersensitive to any comments that are made, and they will say, I feel like I'm being harassed, I feel like I'm in a hostile work environment, because they're hypersensitive. Their hypersensitivity does not mean that they have an actionable claim. It has to be subjective. What would a reasonable person think that was creating a hostile work environment? Now that doesn't mean that you still may want to create that person who's treat that person who's hypersensitive kind of with kid gloves, because you don't want to, when it's subjective, you know, 3 of us in this room could say, well, that's not hostile, and 3 of us could say it is hostile, and we don't get to decide. Ultimately, the person who decides whether or not it was hostile or not under the standard is, if you get that far, it's a jury, and so you're always evaluating that. So you have to be mindful of the hypersensitive person, but just because somebody is hypersensitive does not mean they have a claim for harassment. And then the question is, well, it has to be severe and pervasive. Well, then one event can't be severe and pervasive, and that's not true. Depending on the circumstances, one unwelcome act may be sufficient to create a hostile work environment. And the example here, which I think we all can agree is one that fits that category, but there could be different ones, is that a male co-worker came behind the plaintiff as she was seated, grabbed her breasts, lifted her up in the air, and rubbed her buttocks up and down against the front of his body 3 times before dropping her. She landed off balance and he pushed her into a fence. Court said that these actions, although one occasion, qualify undeniably as unwelcome sexual conduct if it's established a hostile environment. That's pretty obvious. One event that we would all probably agree is a hostile work environment, just one event. But there can be variations of this. You know, somebody can make a very derogatory, one time can blow up and go on a racial tirade against somebody. And that in and of itself, just one event, might be enough to create a hostile work environment. Next slide. Recognizing harassment, some examples. Next slide. So race, color, national origin, religion, some of these others. So here's some examples of where harassment might apply. Addressing employees of color in a racially or ethnic derogatory term. I think we can all recognize that. That can certainly create harassment under race or color or national origin. Displaying derogatory racial, ethnic, or religious graffiti, notes, or signs. Be careful of what people post in their workspaces, especially if they're kind of public or other employees around them. Somebody puts up cartoons that are racially or ethnically or religiously offensive. Those can certainly be actionable. Permitting employees or students to refer to minorities using ethnic or racial terms or slurs. Exposing minorities to hate messages or symbols. Making offensive remarks or jokes about religion. Lecturing a coworker about their religion or questioning his or her religious belief. Suggesting that she talk with God or that they need to go to church or anything like that that deals with someone's religious beliefs could fit into the category of harassment. Next slide. Conduct directed at employees' religious tradition, clothing, customs. You have somebody that wears headgear or something like that because of their religious beliefs or does certain practices and you make fun of them for that. Or the way they speak could, if it becomes pervasive again, could rise to the level of being harassment because of religion. Treating anyone of color in a less dignified or professional manner than Caucasian employees, such as assigning menial tasks or difficult work that Caucasian employees in similar positions are not required to perform. Failing to inform minority employees of or bypassing them for promotional opportunities. Assigning work opportunities based on race or national origin. Next slide. What are some examples of disability? And you certainly are all sensitive to this. And I apologize for some of the language here. But referring to someone as a cripple, excluding someone because of his or her HIV positive status, asking a coworker to disclose details about his or her medical condition, displaying derogatory disability, graffiti notes or signs relating to disabilities or someone's disabilities. And as you all know, disabilities have a very broad range of things that fall into disability. It can not only be physical disabilities and mental disabilities, but it can be emotional or mental health type disabilities that fit into this. So we need to be sensitive to that. Next slide. Age, one we probably don't necessarily think about often, but age harassment, again, occurs to anyone that's 40 or over. So as I mentioned earlier, making fun of someone or harassing someone because they're too young may not be a good practice within the organization, may not be good for morale, but it's not actionable. But if you do start to harass or create a hostile, work environment for someone who's 40 or over, then age discrimination does come in. So comments about the physical changes associated with menopause might seem innocent enough, and that might not be harassing if it's two people who are going through the same situation and discuss it, and it's not unwelcomed and things like that. But making fun of somebody about hot flashes or so-and-so, you seem upset today, you must be going through hot flashes or menopause or something. Those types of things could fit into age discrimination, or it could be sex discrimination or harassment as well. Attributing unsatisfactory work performance to senility or Alzheimer's, although oftentimes we ourselves make self-deprecating statements about how I must have Alzheimer's, things like that. That's certainly, if I'm making it about myself, that's not necessarily, that's not harassing, but if you make comments about other people and it creates a harassing environment. Repeated questions about when an employee plans to retire. Repeated urging of an employee to retire. Repeated references to an employee being overqualified. Displaying derogatory age graffiti notes or signs. Again, if it becomes persuasive, that can be age harassment. Next slide. Sex. We kind of talked about this. Physically harassing conduct can be touching, pinching, hugging, kissing, or cuddling, looking down a woman's blouse or upper skirt, brushing against someone, persistently invading another's personal space, placing a hand on another person's leg, knee, or thigh, impeding or blocking another person's movement, physical assault. So it can be some things, if it happens repeatedly and it makes somebody feel uncomfortable, can be considered harassment related to sex. Next slide. Visually harassing conduct, having, pictures hanging in your workspace, displaying printed language, obscene hand gestures, leering, which is hard to define, obviously, revealing body parts that violate common decency, giving sexual novelties as gift or something as a joke, not a good idea. Next slide. Verbally harassing conduct related to sex. Again, we talked about requesting sexual favors, vulgar or obscene jokes, demeaning or degrading general-based references, suggestive sounds, starting or spreading rumors about an employee's sex life, commenting on an individual's clothing or body in a sexual way, unwanted communication, repeatedly asking someone for a date after being turned down, bragging about sexual conquests or capability or asking people about that, intimate questions or suggestions, making anti-feminist comments or expressing views about women and their role or appropriateness in the workplace. Next slide. Be aware of the potential dangers associated with the internet. Emails with employees. Emails are easily misinterpreted, so be careful. Don't make sort of off-the-cuff comments that you mean very innocently, but somebody on the other end may interpret it differently. And those emails will always be around, and they're pretty good evidence for somebody if they can dig up some of these emails, even though they were meant harmless, and I was just passing on a joke that I found from somebody else, which is this posting inappropriate sexual comments, videos, or photos about coworkers on social media, text messages and photos. Again, be careful about all those. It's so easy to pass on this joke that I thought was really funny to somebody else, but it may make somebody else uncomfortable. Let's move on to the Family Medical Leave Act. Next slide. So the Family Medical Leave Act is something that we've had in Indiana for 20 years, or in the country. It's a federal law for 20 plus years probably. And it's a method, as you probably all know, that allows people that have a family health matter or have birth of a child or adoption of a child, allows them to take off time. Doesn't necessarily require that they be paid. There's talk about Congress passing or states passing laws like that, and some states have, but requires you as an employer, if you meet certain requirements, the employee meets certain requirements to allow time off over a given period to deal with those issues. So as supervisors, it's important for you to be aware, not only for your rights to FMLA, but really for this discussion, to recognize and how do you deal with FMLA issues for people that you supervise so that you can identify them and get them to HR or other people to make sure that the organization has the knowledge and make sure that it complies with the Family Medical Leave Act. So Life Designs is a covered employee because it applies to any employer that has over 50 employees. For the employee to be eligible, though, they have to have been employed for at least 12 months. So somebody that's in their first year of employment and Life Designs is not covered by the FMLA. They have to be here for 12 months, and they have to have been employed for at least 1,250 hours of service during the 12-month period immediately preceding the start of the leave. So if they don't work enough hours, even if they've been here 3 years, if they're working 1,000 hours, then the FMLA does not apply to them. Now, you can still give them leave, you can still choose to do things, you may or may not choose to do that, but the FMLA requirements don't apply to them. And employed at a work site with 50 plus employees, but you, again, that's going to, FMLA is going to apply to Life Designs across the board. What is an eligible employee entitled to receive as under the FMLA, the federal law? What the law says they're entitled to receive is 12 weeks of leave in a 12-month period. Now let's talk about two things. We'll talk about more of them later. 12 weeks of leave does not have to be consecutive. It can be intermittent. It can be part of a day, and once it all adds up to 12 weeks. So that could be 24 weeks of half days if that's a legitimate FMLA leave. So it's not just 12. It's not a part of a day is not a full day for the 12-week period. And then a 12-month period can be important too, because some employers define that differently, and the statute allows you to define it differently. It can be a 12-month calendar year. It can be a 12-month fiscal year. It can be a rolling 12. What is a serious health condition? And this is one of the tricky things to apply, is what is a serious health condition so that someone's entitled to FMLA. The basic definition is an injury, illness, impairment of physical or mental condition, which makes that difficult, that involves inpatient care or continuing treatment by a healthcare provider. Inpatient care is an overnight stay and any period of incapacity and subsequent treatment in connection with the inpatient care. An injury, illness, or impairment or physical or mental condition that involves inpatient care or continuing treatment by a healthcare provider that involves more than 3 consecutive days, or 2 times within the 30-day period, or treatment at least once resulting in a regime of treatment. So it can be incapacity for pregnancy or prenatal care. It can be partial time off because I have to have chemotherapy treatments every 2 weeks, and after I have chemotherapy, it takes me 2 days to recover. So I'm going to have to take 2 days off every 2 weeks to recover from my chemotherapy. Well, they're going to be entitled to FMLA leave related to that. Going to page 11, an illness, injury, impairment, or physical or mental condition that involves inpatient care or continuing treatment by a healthcare provider includes for chronic serious health condition, for treatment over an extended period of time. So these can drag on, can be for long periods of time. What can you require? Well, you can, the individual who wants an FMLA, what needs to provide a medical certification. If they want to take leave due to a serious health condition, the employer may require certification, sufficient medical facts to support the need for the leave, info to establish the employee cannot work or perform the essential job functions when they need the leave, and the employee is required to submit a complete, sufficient certification signed by a provider. And then generally, if they have provided a complete and sufficient certification, the employer cannot request additional information, but the employer may contact the healthcare provider for the purposes of clarification and authentication of the document signed by the physician, and can inquire to make sure that the physician did file the certification and that they understand that the information is in there. If you doubt the validity or continuing status of an employee, you can request a recertification, typically every 30 days. An employee, if they know they're going to be out, they know they're going to be out for knee replacement surgery. that employee should obtain that certification in advance of going out. But there are times, I had an emergency appendectomy last night. I didn't anticipate that. They're going to have time to submit their leave certification after they're out. One of the trickiest situations for any supervisor or employer is dealing with intermittent leave, when somebody wants, a day off a week, and they want to come in late and do those types of things, or they're gone for 12 weeks, and you as a supervisor need somebody in that job. I need somebody in here, I need to hire somebody else because I need somebody in here. Dealing with that, when is intermittent leave legitimate, all of those things are important things to have to deal with as a supervisor and employer. That's something that you need to talk with HR and things if you get into those situations. Typically, FMLA is leave is unpaid. I talked about that. When someone returns from leave, employee is entitled to return to the same position. So this is where I want to hire somebody, but 12 weeks later you need to understand that this employee, as part of their FMLA leave, is entitled to return to the same position or a substantially similar position. And to be substantially similar, it has to be, generally speaking, have the same pay, the same benefits, the same working conditions, and the same or substantially similar duties and responsibilities. So let's say you hire somebody to take their shift, and now they're ready to return, and you don't want them to return to your shift because you like the new person better, and you offer them, maybe the first shift was a day shift, now you offer them a night shift. Well, it's going to be the same pay. In fact, it might even be greater pay because it's a night shift or something. Well, the argument would be that that's not going to be substantially similar in duties and responsibilities because I don't want to work at night, and that's a different job if I'm working at night. And so they may argue. Now, if it's, let's say for instance that it's working at one home that you have, and when they return they're not going to be able to go to that same home, but they'll be able to go to another home, which is really the same type of deal. It's going to be the same pay, their job's going to be the same. You could probably do that without having an issue under the FMLA under that circumstance. An employee does not have greater rights to reinstatement or other benefit conditions of employment than if the employee had been continuously employed. So example, if while they were out on an FMLA leave, let's say you had a home which had 6 employees working in it, and you decided that you could no longer treat those employees or deal with those customers, or all those customers left, and you decide you had to shut down that house, and everybody that was working in that house was going to be laid off. And it so happens that this person that was on FMLA leave was in that house and would have been laid off if they were working at that period in time. Well then, when that person when their leave is over, or even before their leave is over, you can basically tell them, everybody in that house has been laid off, you're not going to have a job when you come back. Now that's a very tricky area also, so you need to be careful in doing that, but the law does recognize that possibility, although they don't like it and they don't make it easy to do. Notify employees when time is used towards their 12-week entitlement, so it's always a tricky thing, but HR needs to be saying, hey, make sure everybody's on the same page of what days are counted FMLA, what days are something else, so that you've got a total employee and everybody's on the same page with that. Notify employees when their 12 weeks have been used, so you don't have issues there. Notify employees of their rights and responsibilities under the FMLA. Make sure that they receive those notices, because if they're out of the office on FMLA leave, they're going to say, well, I never got that letter that said that my FMLA leave was up or that you needed another certification. Make sure that they get it either by personal delivery or certified mail. Next slide. Be very careful with the potential intersection between the FMLA and the ADA. And this is a very tricky area that can come up. After an employee's 12 weeks is up, they were off for 12 weeks, their next 12 weeks eligibility is not coming up for 6 months. they cannot return to work after 12 weeks, then they don't have any other job protection under the FMLA. You can terminate that employee, at least as far as the FMLA is concerned. Where it gets tricky is that the EEOC takes the position that additional time might be a reasonable accommodation under the ADA. So here you have somebody that's off work, and you have to make a couple of analyses. One is they can't come back to work full time, but you need to have an interactive discussion with them about, are there some reasonable accommodations that we can make for you to allow you to come back to work to perform the essential job functions? So if there are reasonable accommodations we can make for them to come back to perform the work and perform the essential job functions, and they're reasonable, then we need to make those and have them come back to work under those circumstances. It could be a reasonable accommodation that I can't come back after 12 weeks. If I have 2 more weeks, I can come back. The ADA might take the position that if they can come back after that 2 more weeks and perform the essential job functions, maybe giving them that time off is a reasonable accommodation that you have to make. Or maybe it is that they can work they can't come back full time, but with reasonable accommodations they can come back half time for 2 more months, and then full time after that. The ADA, EEOC might take the position that you have to make that kind of accommodation for them. So while they don't have anything, they may still have that. Apply policies, practices, etc. in a consistent manner among employees. Be careful about allowing somebody to be off for a long time, or allowing somebody to be off for one situation, and then a nearly identical situation comes up for somebody else and you say no. That's going to create problems for you. Do not ask for more information than necessary in a medical certification to be able to determine that they meet the requirements. Recognize when an employee may need FMLA leave, and this is where you supervisors come in. The employee doesn't have to say, I need an FMLA leave to be eligible for it. So again, you can't bury your sand bury your head in the sand. Employee calls and stated she needs a few days off to care for a recently hospitalized mother. That should be a trigger to say, well, maybe you need to apply for an FMLA leave. Talk to HR or whomever the case may be. Next slide. With intermittent leave, be careful to follow the rules about requesting recertification. You can only do it every 30 days. It's tempting to request more frequently than permitted if you suspect the employee is abusing that policy, but you can only ask so many times. And do not make employee perform substantive work while on the FMLA leave. Don't say, I'm going to send all this work home for you to do while you're sitting at home recovering from surgery. You can't require them to do that. I think is there any more slides? I think that's the end of it. Yeah. If you have questions about what to do or what not to do in a particular situation, contact HR or legal counsel. There are many nuances to the law and the court cases that have interpreted the law. There's a good website here. It's a blog on multiple FMLA issues by the Chicago attorney and IU grad who's put that blog together. So I think that is it. Anybody have any questions?